Good afternoon.
Good afternoon.
My name is Christine Njagi. I serve as a senior resident magistrate at the JKI Law Courts, and I wish to take this opportunity to thank you for inviting me the second time to come and give this presentation. I'm going to give my presentation on the legal framework on human trafficking, looking at the international, regional, and national frameworks that we have. So that will be the outline, the introduction, the international, then the regional, and the national framework. So on the introduction bit, I think we've dealt a lot on what human trafficking is, together with the reference, looking at the definition within the Palermo Protocol. So looking at the international legal framework, the international law is formed basically from a body of principles and rules which are guided and inform countries from an international perspective. And we have also various recommendations and guidelines that look onto the issues of human trafficking from the United Nations High Commission Office for Human Rights. So looking at the international instruments, we have the UN Convention Against the Transnational Organized Crime, which came into force in September 2003. And then we also have the Palermo Protocol, which looks at the definitions of what human trafficking is, and this is the major guiding international instrument. So Article 3 gives a definition. At Article 5, we have the criminalization of human trafficking. Article 6, the assistance to protect victims of trafficking in persons. Article 7, the status of victims. Article 8 deals with the repatriation, which is part of what we have been having discussions on. And Article 9 looks at the prevention of trafficking in persons. Then we also have the protocol against smuggling of immigrants by land, sea, and air, which came into force in 28th January 2004. And we have two International Labour Organization instruments, which also looked at the issues of forced labor, being the Forced Labor Convention of 1930, as well as the Abolition of Forced Labor Convention, which was in 1957. We have the Convention on the Prohibition and Immediate Action for the Elimination of Worst Forms of Child Labor, which was adopted in Geneva in 1999. And what I did is just highlight some of the articles that touch on issues of child labor. Article 1 notes that members are to take immediate and effective measures to secure prohibition and elimination of worst forms of child labor. Article 2 looks at the definition of a child as someone who's below the age of 18. Article 3 gives the worst forms of labor, and it gives the definitions of looking in practices of slavery, offering children for prostitution, procuring or offering a child for illicit activities, as well as harmful or circumstances that bring harmful situations of health and safety to the morals of the children. There's also the Slavery Convention, which was signed in 1926, and it also looks at the definition of what slavery is, and it's a condition of a person, or it's having a person, or condition of a person over whom any of the powers attaching to the right of ownership are exercised. So it just gives the definition of what slavery is, together with the acts that look or are involved in what slavery is. The other international instrument is on ICC PRC, which is the International Covenant on Civil and Political Rights, which relates to trafficking, including slavery and counting slave trade and servitude and forced labor as part of human trafficking. We also have the other International Convention on the Suppression of Traffic of Persons and the Exploitation of Prostitution. I think this is where now maybe we're also trying to cover what Sweden is talking about on the issues of the Nordic model, but this also looks at the issues of prostitutions and criminalizes or gives definitions on issues regarding procuring and leading others or trafficking someone for issues concerning prostitution. The other international instrument we have is on, did I go back? Yeah. On the cover on the elimination of discrimination against women, where it defines what discrimination against women is. And then also at Article 6, it notes that all state parties have to ensure that they have legislation that suppresses trafficking women for exploitation of prostitution. Then we have General Recommendation number 19, which identifies trafficking as a form of violence against women, and it puts women at special risk of violence and abuse, especially when they're being trafficked. And it is trafficking is incompatible with the equal rights of enjoyment of all women. We also have subsidiary sources and soft laws, which are decisions from the international courts and tribunals. I believe my colleague from Tanzania shared on the ICC, as well as we have the mutual legal assistance agreements, which we have been seeing as mechanisms to enable us obtain evidence from other foreign countries, or even get to be able to have agreements with these nations to be able to repatriate the persons who have been rescued from these other countries. We also have extradition treaties where we can extradite or we can request extradition of perpetrators so that they can be tried within our state. And a point in cases where we had one person who was extradited from Kenya and they were actually tried in the States on issues of human trafficking. We have also the SGDs, looking at SGD number 5 on gender equality, as SGD also number 8 on decent work and economic growth. If we achieve decent work and economic growth, which is a discussion we're having over lunch, then we ensure that this vice of human trafficking is also eradicated. Looking at the regional instruments, we have the Maputo Protocol, which gives definitions of what harmful practices are, violence against women, who is a woman, and at Article 4, it notes that we should condemn the trafficking of persons, especially women, and prosecute these traffickers. Article 5 also gives what state parties should do and also the prohibitive measures that should be taken. We also have the East African Community Counter Trafficking in Persons Bill. This is a bill that's being debated at the East African Community, and what is of note is that it also defines what trafficking in persons should be dealt with within the East African Community. But we are awaiting assent from the East African heads of state in line with Article 63 of the treaty that established the East African Community. And if they pass this bill, then at least we'll have this regional law within our East African Community to deal with the vice of human trafficking. We have the African Charter on Human Rights, which gives, looks at various definitions of what human rights are, and we should also respect the rights of each individual in terms of looking at eliminating discrimination and maintain relations with nations that ensure that rights of people are also protected wherever they go. They're not suffering inhumane treatment or being degraded. We have the African Charter on the Rights of Children, or the rights of the child, and it also looks somewhat to the same as the eliminating the worst forms of child labor. So this is contextualized within the African context of looking at protecting protection of children from sexual abuse, exploitation, forced labor, trafficking of children. So this protocol covers us in that aspect of dealing with children. Well, this word is very hard to pronounce, but yeah. Ouagadougou Action Plan, which looks at combating trafficking in human beings. This action plan has been there for quite some time, but unfortunately, it's yet to be actualized within the context of the African continent. So from the research that I saw is that they lack the manpower, or is it the political will of the states to be able to actualize this. So I think once the states agree to actualize this action plan, then it gives us much more relevance together with the East African bill. Then we can have these two action plans working well within the African context. Now, looking to the national legal framework, I'll come to the Kenyan context, where we are guided by the Constitution and Article 2, sub-articles 5 and 6 of the Constitution, to adopt international laws and instruments to assist us in combating this vice. And we have specialized units within Kenya which deal with human trafficking, one being the Transnational Organized Crimes Unit, or TOCU, and also that deals with issues of smuggling of humans, of adults, sorry. And then we have the Anti-Human Trafficking and Child Protection Unit that specifically deals with efforts of combating trafficking against children. So my senior judge also gave us the articles of the Constitution, where it's our groomed norm that looks at how to deal with the vices, and she has touched on that, so I shall not touch too much on that. We have the draft Counter-Trafficking in Persons Trust Fund guide regulations, which are yet to be developed. This is in line from our major law, which is the Counter-Trafficking in Persons Act, as well as the other regulations which counter trafficking in persons. The main law is the Counter-Trafficking in Persons Act, which was passed on the 8th of October, Act number 8 of 2010. And at Section 3 defines what trafficking in persons is. Section 3.4 looks at the territorial scope of the Act, which goes to Kenya or international across the borders of Kenya. This is where the Mutual Legal Assistance Act also assists us, as well as looking at the offense provided under Section 3, subsection 5, and our fines are up to 30 million with or both, or you can get life imprisonment. I actually gave someone a sentence on this quite recently, so I'm waiting for it to go to the appeal. I see what will happen. Section 4 deals with adopting and offering children for guardianship for other purposes for trafficking, and the penalty is 20 million Kenya shillings. Section 5 criminalizes leasing out of properties. So if your property is, you lease out your property for these issues of trafficking, you are payable to a fine of not less than 20 million Kenya shillings. This also falls in line with the Asset Recovery Unit, which through our Kenyan systems are trying now to go after these houses where people are usually found. So if the asset recovery together with this law apply, then we can be able to get those funds or those monies to be able to put them into the national fund for national fund for the victims. So Section 6 looks at acquisition of travel documents. Section 7, if you aid and abet someone to exit Kenya, or enter, for them to come into Kenya, you're also payable to a fine of not less than 30 million. Or if you interfere with travel documents, you can pay up to Kenya shillings 10 million. The other sections generally talk about other issues regarding victims, and I'm seeing time is really running. So let me go to one of the sections that I really thought, Section 22 on the National Assistance Trust Fund. The fund is there. It's yet to be actualized, but we get funds from proceeds of crime. We get funds from now when we actualize Section 5, where if we sell your property, we can put money into that fund. And also we get funds from Parliament. So this fund is still gathering momentum, though the Act is now 9 years down the line, but the fund is yet to be really, really actualized. So we're hoping once the fund is actualized from all the proceeds that are taken or confiscated by the court to the state, now we can be able to start restituting some of these monies to the victims of this crime. I also looked at other laws that touch a bit on human trafficking, like the Data Protection Act looks at the issue of protecting the data of the victims, as well as ensuring that the data collector does not give out any information regarding victims or any other person. Sections 20 of the Female Genital Mutilation Act talked about aiding and abetting about female genital mutilation, looking at the fact that FGM is something that's very rampant within our country also, but we're trying to combat it. And if you smuggle or traffic someone within the Kenyan context, this section of the law then can apply to you, and you can be penalized and pay a fine of not less than 200,000 or to both. We also have the Sexual Offences Act, which looks at certain sections that deals with criminalizing sexual exploitation, where we see also a lot of people, especially around the coast, are trafficked or smuggled for sexual exploitation, especially children. So if you do promotion of sexual acts with children at Section 12, the fine is 500,000 Kenya shillings. Sex tourism with a child, the fine is not less than 2 million. Child prostitution, you will serve a sentence of not less than 10 years. Child pornography, trafficking for sexual exploitation. So the SOA is also in line with also what the Counter-Trafficking in Persons Act aims to look at when we're talking about trafficking of persons for sexual exploitation. The Penal Code also looks at other sections of looking at issues of sexual exploitation, because at Section 151, if you detain females for immoral purposes, you're guilty of a felony. And a felony, I think, is not less than 7 years within our jurisdiction in terms of imprisonment term. And we've also seen that if male persons living on the earnings of prostitution or soliciting, the penalty is also guilty to a felony. I've also looked at other sections which also tie into the whole issue of human trafficking. You'll forgive me, I'm rushing. We are looking at also the Witness Protection Act, which looks now at the rights of the victims. And at Section 3I provides for the Victims Compensation Fund. And Section 4 provides how the funds shall be paid out and for what? For restitution, for compensation, and for any other monies to meet the expenses of this person. The Victim Protection Act also talks about restitution of the victims. Sorry, I think my time is up, but thank you. That is on the recommendations. My senior is going to speak about that. Thank you.